Hi, good morning. A very interesting judgment from Bombay High Court. The citation is Purushottam Prabhakar Chavan versus Deputy Commissioner of Sales Tax. Even though the sales tax authorities are now, they have become GST authorities. See, the facts of the facts are very lengthy facts. So I want to put it in a nutshell. A bank sanctioned credit facilities to a partnership firm, a private limited company, and a proprietorship firm. Facilities were secured by a combination of mortgages created over the properties. The loan taken by the firms were classified as NPS. They did not pay the amount, so it was classified as NPA. In the meantime, the Assistant Commissioner of Sales Tax passed an order of restraint in respect of some of the properties which did not cover the property under question. That is a flat. A flat in a Bombay was also attached by the Deputy Commissioner of Sales Tax. This was also mortgaged before the bank in lieu of the loan taken by the purchaser, the companies. The lender bank issued notice under Section 13(2) of SARFAESI Act. Then they took possession under Section 13(4). This was followed by application for physical possession. The Deputy Commissioner of Sales Tax wrote a letter to the lender bank saying that these assets were secured under the Maharashtra VAT. They also issued a notice under Maharashtra Land and Revenue Code prohibiting transfer of this property, this flat. A warrant for taking possession of the secured asset was also issued by the Deputy Commissioner, and the process of triggering recovery proceedings was initiated. The lender bank wrote to the Deputy Commissioner saying, no, no, we have the priority because this was mortgaged by this flat was mortgaged, and hence we have the first right, first priority. They registered the mortgage with the Central Registry of Securitization and Security Interest. Hereafter, I will say, because lengthy one, Central Registry. The loan was assigned to the asset reconstruction company. The asset reconstruction company, then they sold this flat by way of a auction sale. The society, when the purchaser, he went to get the with the sale certificate, he went to the society and wanted to take possession. They said, no, no, you get a no objection certificate from the Deputy Commissioner of Sales Tax. Obviously, that Deputy Commissioner of Sales Tax has issued a notice to the society also. The buyer was unable to have the property transferred in his name, and then he filed a writ petition before the Bombay High Court. Issue before the Bombay High Court was whether the auction purchaser under the SARFAESI Act is a valid recipient of free and marketable title to it. Both the lender bank and DCST, they both said, no, no, we have the right. So DCST said, no, no, he has no valid title because we have the first charge. Bombay High Court held. In the opinion of Bombay High Court, the conflict is no more res integra because of operation of Chapter 4A of the SARFAESI Act. Bombay High Court says, even where multiple creditors have registered their security interest over an asset with central registry, the order of priority of such security interests would follow the sequence in which such registration has been effected. The enforcement of security interest registered with central registry prior in time would have priority over any subsequent security interest registered over the same asset. As per Section 26E of the SARFAESI Act, once a secured creditor registers its security interest, notwithstanding any other law in force, the debts owed to such a security creditor shall be paid from the proceeds of enforcement over the asset in priority over all other debts, including taxes payable to the state government. Tax authorities cannot claim priority over the dues payable to the security creditor. whose security interest is registered with central registry. That is main point. Even if you are a tax authority, you cannot claim any priority over the dues payable to the security creditor because he has first went and registered it before the central registry. In this case, the lender bank registered the mortgage first. There is no record of any registration of attachment by the DCST. The priority of claims can be determined only with reference to the sequence of registration with central registry. Prior to first attachment order by DCST, various measures were also taken by lender bank. We should notice first, and then they took possession, then they applied for physical possession also. Section 37 of Maharashtra Act will override any provision of the contract that creates a charge. That is the section. But it is subservient to any provision in a central act which gives first charge to some other entity. Therefore, when the asset reconstruction company enforces the mortgage, it will have priority over the statutory first charge against the claim of the DCST. The purchaser will have the benefit of a clear and marketable title to the flat, free of all encumbrances, since it was the enforcement of a security interest enjoying priority that led to the purchase of the flat. Once the mortgage is enforced against a security asset, there would be no scope for any further enforcement against the same asset. This is very important. Once they have enforced, then another fellow cannot come against the same property and say, I will also enforce. The charge enjoyed by creditors with lower priority, in the present case it is the DCST, would then move to the proceeds of the enforcement. After such proceeds have been deployed towards the discharging the claim, enjoying a higher priority in full. That is, the first fellow will take whatever is there, he will consume everything. Balance, if any left, then only you can enjoy that. The residual amount of such proceeds would then go to the creditor with the next creditor with the next priority. So balance left only you can enjoy. The Bombay High Court made the following directions. Lender bank has first priority against the asset, since this was the first registered with the central registry. 2. Asset reconstruction company who conducted the auction acquired entitlement to priority from the lender bank along with assignment of the loans with attendant security interest. 3. Even though DCST has issued orders of restraint, there is no evidence of registration with the central registry. So it seems registering with the central registry is very, very important. Even though you have a claim against the property or asset, you have to first register it with the central registry. Then only you will have the priority over the claims. 4th, the attachment orders issued are of no assistance in giving priority to the DCST, that is Deputy Commissioner of Sales Tax. With no registration with central registry and no proclamation of sale having been issued, the lender bank's entitlement to priority will not be undermined. Then 5th point, any attachment sought to be made by the DCST over the asset towards arrears of sales tax was quashed by the High Court. 6. DCST is entitled to any residual proceeds from the sale of the asset after discharge of dues owed to the asset reconstruction company. 7. DCST can chase against the other assets of the sales purchaser against the sales tax dues. There is no restriction for that. That is what Bombay Court rules. Simply put, when there is a claim by the bank or the asset reconstruction company and there is a claim by the tax authorities, Bombay Court says who registered first in the central registry, that fellow will have priority over the claims. This is based on a full bench judgment of the Bombay High Court, and the tax authorities cannot say, issue a notice attaching the same property by saying no, we have the priority over all the charges. They cannot say that. That is what the judgment says. Interesting judgment. Finally, the writ petition was allowed, and the society was directed to give the no objection certificate for registration. Thank you very much. Have a great day.